Hey guys, good morning. We're going to be getting started in just a minute, so hold on, please. I'm sure someone's going to come in and say they don't hear anything. Where's the sound? All the things. I'll be right back. I'm right here, sis. I just ended another live, so I needed like a reset moment. And then I also found something that we can talk about while we're hopefully not waiting too long for court to start. So give me just a minute. Okay, guys, good morning. Good morning. Good morning. Good morning. You guys know what we are here for. Let's get into something really quick. What time is it? We might have a few minutes. I feel like we have just enough time. Hold on a second. Let me pull up this video. Guys, I did create a playlist. Guys, Kathy's here, our good friend from over Gossip Rumor Innuendo. Kathy does her morning recap of what's going on. So make sure to go. I'm out of breath, y'all. Oh, okay. Lambo took off with one of my shoes real quick, and that just anyway. Anywho, Kathy does her morning recap. Go catch it. I have a playlist of what we've been covering so far, daily trial, outtakes of particular testimony. I haven't done a specific video of the testimony of Mrs. Perry, the former Mrs. Perry, now Archie, because pretty much she was the only witness on that day. So I almost feel like the day was her day. It's interesting that they started the first witness and the last witness. First witness, the wife; last witness, the mistress. Very interesting as well. Um, so much to talk about. We'll talk about this. I just need some time to process. After they do the closing arguments, we can have some conversation regarding the matter. I'm still processing this whole thing, but guess whose Instagram I found? And we're going to go over there as soon as I finish this. But I think I found Mr. Brodes Perry's Instagram because Latasha was doing so much talking yesterday. I started doing some searching and I feel like I found his Instagram, but I'm not 100% sure. So we're going to go take a nice little trip over to Instagram after we watch this and see if I'm right. Okay, hold on. Let me share my screen. And then of course I'm also monitoring court TV. So as soon as court TV comes on, we'll save whatever else we have to do on our list of items to then. Okay. All right, let's listen to this. This is the cross-examination by the prosecutor of Latasha. Most notably, just the attitude shift and change. Her attitude changed immediately when the prosecutor started taking her to task for her decisions, right? Very interesting, right? Let's get into it.
Did you ever intend to hurt Tabitha?
No,
Did you even realize that you had shot her?
no.
That's all I have.
Cross-examination.
Ms. Daniels, I'm going to take you back to April 4th, 2019 at around 4 o'clock. You remember yesterday when we introduced that surveillance footage of you at the gun store, right?
Yes,
And you know that that was you in the gun store.
that was me.
And you purchased a gun that day.
I did.
And you also purchased ammunition that day.
I did.
And when you went to that gun store, you brought your state-issued ID, correct?
Yes,
And you brought your credit card, correct?
I did.
And once you left with that gun and the ammunition, you didn't go to Jacksonville, did you?
No,
You drove to Memphis.
no. I drove home.
All right, let me stop right there real quick. Not only is the prosecutor skillfully laying out intent, but I also think, and you had an opportunity to take your ass to bed. You were having a stressful day, a stressful moment. You felt some type of way. You went home. You said you wanted to harm yourself. You went home and then you went back out. You had time. You stopped at the house. And then you got on the road and then you saw the sign to Memphis. You knew, I'm sorry, I think she knew she was going to Memphis the whole time. Like someone said in the chat, she's had 5 years to think this whole thing out. As far as I was actually going here because it was representative of so many different things and da. Girl, stop.
But you eventually ended up in Memphis, did you not?
That is correct.
And you chose to go see Brodes Perry, correct?
Yes, I chose to go see him.
A man that you chose to be involved with.
When I first encountered Mr. Perry for counseling, I did not choose to be with him. I went to him for direction, not a relationship.
It's a yes or no question. You chose to be involved with him after you met him, did you not?
Yes,
And when you got to Memphis, and after you talked to Mr. Perry, you drove to his apartment, correct?
yes, I drove to his apartment.
And from Sherman, Arkansas to Memphis, it's about a 3-hour drive, right?
According to what has been said, I wasn't counting.
And when you got to that apartment, you talked to Mrs. Perry.
Yes,
And when you got to that apartment, you stayed there and you talked with her for about 20 minutes. Correct?
yes, we talked for about 20 minutes.
And then once Mr. Perry got there, you talked to him.
Yes,
And while they were gracious enough to walk you out of their apartment after an unexpected visit, you got your gun out, didn't you?
it wasn't unexpected for him.
But for Miss Perry, it was.
It was.
And after you exited, you decided to take your gun out, correct?
No,
And after you exited, you shot Mrs. Perry, did you not?
my
Yes or no?
actions resulted in them being shot, yes.
And then you shot Mr. Perry, did you not?
It wasn't a conscious decision, but yes.
But you didn't do it because you lost control. You did it because you thought he deserved it.
No. I love Brodes. I would have never intentionally hurt him. No, ma'am.
You did it because he broke your heart.
No, ma'am.
No further questions, Your Honor.
Were you in a good state of mind that day?
I was not. I was
All
not.
day?
I was not my healthy self. No.
When you came to Memphis, did you come to Memphis out of anger or out of love?
I came out of love.
Did Brodes expect you to be there when he walked in?
Yes.
Did that visit go the way that you expected it?
It did not.
Did it end the way you expected it to?
It most definitely did not.
Did you go there to hurt anyone?
No, I did not.
Who did you plan to hurt
I
that
wanted
day?
to hurt myself. I wanted to end my own life that day. That's it, and that's all.
That's all I have, Your Honor.
No recross, Your Honor.
You may sit.
You may call your next witness.
Your Honor, may we approach?
Yes.
Okay, we're back. Let's see. Okay, guys. I felt like the prosecution did such a good job questioning her. Like they just laid it out so well. Like just her intent of the day. You did this, you did that, you did this, you did that, then you did this, then you did that. I mean, there's not really a whole lot that she can come back from that, in my opinion. I don't know what you guys think, but in my opinion, sis, it's not gonna be good. It's not gonna be good. Mm, Okay. Let's pivot over here. Hold on a second. I just want to get us set up for when court starts. They're on the medallion, so clearly they're in court. I'm not sure obviously what they're doing. They could be going over the instructions. You know, sometimes they will go over instructions with us, we can hear, but maybe this judge doesn't want that. I don't know. I think she believes her lies. I don't believe them. I don't know. I think she's used to making a lot of excuses. Let me think about what you said. You think she believes her lies? I think she believes her ends justify the means. So maybe we're saying the same thing. I think in her mind, she has decided that oops is good enough. Like, oh, I didn't mean to, like, my bad. It's the my bad defense. I didn't mean, like, that wasn't what was supposed to happen. Like, I was supposed to go home and handle my own business, but I decided to get in the car and go to this random place that I thought would mean something. But when I saw that Memphis sign, I could not help but take a damn detour and drive my ass 3 hours with no purse all the way to my married boyfriend's house, who just broke up with me on the app Confide. Okay. All right. While we still have a moment, let's go over here real quick. So do you guys remember that she said, I'm trying to get to the bottom of this feed because I think this is him, but this guy took so many freaking pictures of damn cigars. It's ridiculous. I want the bottom of the feed, because I feel like there's something here that's going to tell us, and maybe it's the glasses. Are these his glasses? Hold on. Oh, okay. Maybe I found a clue. Hold on a second. Are those his glasses? Let's see. Look at the glasses. Maybe not exactly the same, but the same style, potentially. There's going to be some clues here. But remember, Little Rock, Arkansas. Dave and Sands. Oh, that's the club that he belonged to. Okay, well, I think I did find Mr. Brodus's Instagram, the Smoking Savant. Okay. The Smoking Savant, and he's checking in at a cigar bar near you. Before our time is concluded today, I may find Mam's Instagram. We'll see if we can find her social media. She better stop playing. Don't play with this internet. Don't play with this internet. Girl, internet remains undefeated. I was like, the Smoking Savant. Let's see. And I Googled Smoking Savant, and baby, girl, there might be pastors that smoke. I wouldn't have a problem. You know what? I remember when I was very young, we were members of St. Cecilia's in Englewood, New Jersey, Roman Catholic Church. And baby, one of the priests, one of the like the main priest of our church, he smoked pipes. Like they smoke. They may not smoke pot, but some of them do smoke. Okay, the court's getting started, y'all. Hold on a second. Let me pivot. We'll get back over here. Okay. All right.
With some cases also, but the criminal attempt, first degree murder, and pulling a firearm, the defense had provided me with some cases also. Mr. McAlpine sent me a case as well, State v. Claxton. W20090167 CCAR3CD. And so after reviewing those cases, again, the standard is, after viewing the evidence in light.
Okay, drink wine and everything. Yeah, I'm going back on mute, guys.
Most favorable to the prosecution, any rational trier of fact could find beyond a reasonable doubt that the defendant is guilty of the offense. And Millen versus State laid out what the standard is. In short, if evidence demonstrates that the defendant intended to cause or result the death of a person, that he did so with premeditation and deliberation, then the killing of another, even if not the intended victim, intended result is first degree murder. So also, State v. Claxton sets forward things that can be considered for premeditation: the use of a deadly weapon upon an unarmed victim, the particular cruelty of the killing, declarations by the defendant of the intent to kill, evidence of procurement of a weapon, preparations before the killing for concealment of the crime, and calmness immediately after the killing. And so in considering those things, the court finds that there is sufficient evidence for this matter to go forward with the jury, because although the defendant may not have intended to kill Ms. Perry, the law says that all that's required is that she had the intent to kill a person, and that person would have been Brodes Perry, who was shot multiple times. So in considering all those things, the court finds that there is sufficient evidence for this matter to proceed to the jury. I know there was some indication about felony murder, but that case also, it says something about criminal attempt murder whenever it's not the intended victim should be felony murder, but that case also says that it can be criminal attempt premeditated murder as well, just not felony murder, just when it's not the intended victim. So the court finds that there's sufficient evidence, and because the court finds that there's sufficient evidence on criminal attempt murder 1 and count 2, the court also finds that there is sufficient evidence for the case to go forward to the jury on employment of a firearm. As indicated in my previous ruling, the defendant used the allegation that she used the firearm in commission of the criminal attempt murder, which the court finds that there is sufficient evidence for that to go forward to the jury that she did so intentionally. So the court's gonna deny the motion for judgment of acquittal at this time.
Thank you, Your Honor.
And then there was a second issue, and I guess we can approach it like that. We can approach it like that.
All right, we have a little bit of time. Let's see. Oh, not an updo today. It's just the stylings of the wig for me. Okay. Is she trying to pretend that it's not her?
On the criminal attempt, first degree murder. And I think she sent that out to you. Were there any corrections or anything from what the party saw?
I did, Your Honor. I don't know if the state wants to go first.
I just have one issue that and it's always been something I haven't understood. So when the definitions of intentionally and transferred intent is in second degree murder, but not in first degree murder, and I don't understand why that is.
You said second.
Right, and so my position is that that language should be in the charge for murder one, because it is a criminal attempt murder one. It doesn't
Criminal
affect.
attempt second degree murder, or just second degree?
Well, so, yeah, so the transferred intent element is, so the criminal intent, by the time you get there, the court is saying, I've already defined.
I changed that.
Oh, did you?
I did.
Okay.
Because the criminal attempt, with serious violent injury, I included, hold on, let me make sure she said she was correct.
And she may have.
We got a corrected one last night,
Okay, it's another.
or this
one.
morning, actually.
Now, let me make sure.
Okay, so they're still arguing her objection yesterday afternoon, so I guess they'll be coming back to that soon. All right. Let me get back on to interesting. Okay. Hopefully this sidebar is not going to take long. Good morning, good morning, good morning, everybody coming in. Court is in session. They are arguing the late objections or the judgment of acquittal yesterday afternoon. So they're still kind of doing a little bit of back and forth, arguing, debating, and I guess we'll have some sort of a decision soon. I don't know if they've settled the matters of the jury instructions yet. They very well may have, but they just got things going, and that's kind of what we're currently listening to. And they basically killed the audio again and put us back on the medallion. So, and here we're back. Please make sure as you come in, make sure to hit the thumbs up for me. And also, if you're not subscribed, please make sure to subscribe and set your notifications. And welcome, 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 welcome. Happy Friday and good morning.
That fixes my issue.
Okay. Did you have anything else?
No, ma'am. That's all.
Okay, all right,
I just note my objection to the change.
okay. All right. Did you have any other changes, Ms. Stevens?
Yes, Your Honor.
Okay.
On page 2, this is a unique situation in that at the last paragraph, or the last sentence of the paragraphs regarding first degree and criminal intent first degree, it says that Latoshia Daniels pleads not guilty to every count as encompassed. To every charge as encompassed. And we are not saying that she is not guilty of all of those offenses. We are saying that she is not guilty of first degree murder. She is not guilty of second degree murder. That this is at best a voluntary manslaughter. So I would like to take that language out, or at least change it to has pled guilty to the originally charged offense, or something along those
Okay,
lines.
which part are you talking?
It's page 2, it's the last sentence.
Oh. The defendant pleads not guilty to each and every offense and breaks and not, you just want me to take that out completely on each one of them?
Yes.
Okay, that's fine, I can do that. Any objection from the state?
No, ma'am.
Okay, yeah, I can take that out. No problem. Anything else?
Yes, Your Honor. Regarding the section on defendant testifying,
Let's see.
it's on,
I know they're not numbers. Let's see.
It's after direct and circumstantial evidence.
Okay, defendant testifying, yes.
Your Honor, I would just ask, it does say like subject to all of the rules that apply to judging the credibility of other witnesses. I would just ask that it be made clear that just like with other witnesses, the law presumes that a testifying witness is telling the truth, and to be given a full and fair consideration. I mean, really that first paragraph of credibility of the witness, minus all of the factors that they need to look at, I would suggest adding into that defendant testifying so that it's clear that the same rules apply for Ms. Daniels as applied to all of the other witnesses.
So what are you suggesting be added? What language are you suggesting?
The, if you go to, it's kind of cross-referencing, if you go to the credibility of the witness,
Okay, I'm
that's
there.
25 pages in, that
Yes.
first paragraph that says, if there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can.
Mhm.
For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide what witness or witnesses you believe and how important their testimony was. You do not have to accept that. Basically, that whole first paragraph for the credibility of the witnesses, but particularly the fact that the law presumes that witnesses are testifying truthfully if the jury can find them. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. Just because it's one says witnesses and one says defendants, so I want to make clear that the defendant is a witness that also has the presumption that they are telling the truth.
Okay, so the language specifically that you want to add is, I want to make sure I have that clear.
If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth.
And then keep her credibility is determined by the same rules of credibility of other witnesses determined. So you just want to add that one sentence.
Yes.
All right, what's the state's position on that?
It's the pattern instruction. It's clear to me. I don't see a reason to change with the instructions from the AOC on that.
was kind of duplicitous because, I'm telling them that she's determined by the same rules of credibility of other witnesses, and then this is a section on credibility of witnesses, and those
Well,
are
then,
the rules.
what we could do in the alternative would be in the credibility of a witness section, include a phrase that, you know, the credibility of the witnesses, the law presumes that every witness, including the defendant in this case, that would achieve the same goal. I just want to make clear that the law also presumes that Ms. Daniels is telling the truth, just as it does with all of the other witnesses.
What's the state's position on that?
Again, I don't know how that's not clear. She's a witness and specifically just tells the jury that they're to judge her by the same credibility as every other witness. Adding anything just like almost emphasizes to the jury that you should believe the defendant more than any other witness in the state's mind. That's not appropriate. So the charge is clear, and it's the pattern charge, and I'm opposed to any change in that.
Your Honor, I disagree. I think that when we have referred to witnesses throughout this entire trial, and we have referred to the defendant throughout the entire trial, those sound like two separate parties. And so if the jury's not clear that even though she is the defendant, she also, under the law and under the instructions, is a witness that should be treated the same way as the other witnesses, then that's impairing her right to have a fair consideration by the jury.
Or can we just say that the defendant is a witness and without
I mean, I think if adding
defendant
that,
having testified, defendant as a witness, having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will have to give the defendant's testimony in this case such weight as you may think it is entitled.
that's, Your Honor, I guess my issue with that is that the language in those two sections are very different. The language between the general credibility of a witness and the assessing the defendant testimony is very different language. Give it whatever weight you think it deserves is very different than the law presumes that these people are telling the truth.
I'll come back to that one.
Your Honor, there also, we had talked a little bit a couple months ago about the Supreme Court denial of certiorari from Sotomayor regarding Tennessee's instructions on second-degree murder and voluntary manslaughter. Justice Sotomayor took the position that Tennessee's instructions for sequential considerations in regards to second-degree murder and voluntary manslaughter are unconstitutional. And that is because voluntary manslaughter actually has an extra element that is not in second-degree murder. And we should be moving down and reducing elements rather than adding them. As far as the order of consideration being sequential, I would ask that the court instruct the jury to consider second-degree murder and voluntary manslaughter together rather than sequentially, because voluntary manslaughter has that separate element that makes it different than second-degree murder, but it's an additional element, an additional finding that the jury would not be able to get to if they did not move past second degree. So I would just ask on the sequential consideration to consider those two together.
What's the state's position?
That opinion did not change the law in Tennessee. It was one justice's opinion who was in the minority. Until the law changes, I think it's clear that the way we charge this in Tennessee is first degree, second degree, and then voluntary manslaughter.
I mean, I get your point. I mean, it makes sense, but, you know, at this time, the law is what the law is. But I definitely get it. You know, it's an additional element, but the law, at this point, I have to follow what the law is currently. And so I note your objection, because I get it's an additional element, and usually when it's a lesser included, it's one that goes, it's a less element, but in this case, there is an additional element, and so it makes sense to me, but, I have to follow what the law is currently, which they go in that order, so I'm gonna have to overrule that objection at this time.
Thank you, Your Honor. And then I would just note on page 39, there was a somewhat duplicative,
Which one?
it was no outside communications, but on page 2, there's no independent research or discussions. I just wanted to note the duplication.
Okay.
And it's not an exact duplication, but it's very, very similar.
Okay. You have any objection to that being removed?
No, ma'am.
All right. All right, give me a second on that other one. I have to step off and do a little research.
Thank you, Your Honor.
All right.
Okay. Thank you so much, Forever T. Thank you for supporting this channel. I appreciate that so much. Okay. Very much appreciated. Guys, okay, let's get over here. You guys asked me yesterday to find Mam's social media, and I've been working hard to I've been being nosy. So I feel like I did confirm this is Mr. Brodes Perry's Instagram. Fran, how do you know? How do you know? Are you sure? Number one, she talked about him creating a tag, the smoking savant. Okay, that's number one. Okay, number two, I scrolled the feed. I looked where he was tagged, and baby, that didn't take long at all. I checked who tagged the smoking savant, and let me see. I feel like I saw a picture of him down here. Hold on. Did I lose it? Oh, here he is. Okay. There he is. Boom! With bad teeth and braces. Bam! Over here at the Distinguished Ruffian. Okay, the Distinguished Ruffian. He was over there smoking. Over there to this man's page. And he's got him tagged right there, the smoking savant. And where's the other thing? Okay, so that's that. There's Mr. Brodes Perry right there looking casual. Now, none of the other pictures are relevant. A bunch of people we don't know. The main, and then he's got him tagged right here, the smoking savant. So this is what Brodes was doing in his downtime. This was July 26, 2018, a few months before Sir passed. Okay. All right. Now, this lady was tagging Mr. Brodes a lot. I don't know if she's some sort of cigar rep or something of that nature. But I don't know. But these are his tags. You know, we're not always responsible for our tags anyway, right? Okay. Then I clicked on his special tag of the smoking savant, and baby, okay. I don't know who these, I don't know. Smoking sweet red lips. Thank you, smoking savant, for such a great smoke. Okay. All right. Then we've got pictures. The Distinguished Ruffian. We are so sad to announce the passing of our Tennessee chapter brother, Brodes Perry, the smoking savant. He's always pleasant man to speak to and kind. Please keep his family in your thoughts. At the Distinguished Ruffian Club is family. Okay. Period. This lady keeps showing up in these smoking savant tags, so I got curious. And she posted, I have to thank Smoking Savant for getting this stick for me today. I had such a great smoke time with you, even though my head cold was kicking my behind. I appreciate your knowledge and background on the lovely Farce Room 101. Please, y'all, take the time and experience this spice jam. Hints of earth, cedar, cocoa, pepper dancing around in my taste buds. So, ma'am is okay. Pretty hair. So clearly a friend, a smoking friend. We don't know who or what, but you know, the smoking savant tag, ma'am shows up a few times in the, I don't know, multiple posts. Okay. Is that the same one? It keeps showing up. I don't know why. Let's see. I don't know what this is. These little chips that they have. He made up, like she said, he made up some sort of a logo and he's got all of these little chips. Maybe he was a Mason too. He might have been a Mason. I'm not really sure what that's all about, but maybe. I'm not sure. They tagged him on something. I guess this is his logo. I don't know what that means in the smoking world. I guess you've got these little chips. I don't know what those do. I have no clue. Anybody who is in the smoking world, what these little chips mean in your smoking journey, you can let us know. But he's pairing these cigars and drinks with each other. Try it Tuesday. I bet you Latasha was not far away. I'm not, look, this was 6 years ago. I don't know. I did scroll down this lady's feed, but I didn't see him in there. But I didn't go in depth. I was just kind of perusing. So we're going to leave ma'am B for right now. I don't know whose dog that is. I feel like Latasha is around here and I'm going to show you. I think Latasha was following him. Latasha's Instagram is private. So I believe I did find it, but it just seems to be private. I don't know why this lady, when her picture keeps showing up. But he kept it kind of faceless. And the only thing that I am seeing is that he did allow himself to be tagged. Is that one of the bottles of bourbon that ma'am bought him? She was spending a lot of money. Ridiculous. And then did he carry a flask? Interesting. Anyway, as you can see, I'm just scrolling and this lady's picture keeps showing up, so it got me curious and I went looking. I don't know who these people are, but I wonder if these are some of his people from the church, all belong to this cigar room together. Let's see. Anyway, let's get back over here. That's on the Savant tag. Is that still the tag? Hold on. Let me see. I just don't know how this guy had time. Yeah, Smoking Savant, Little Rock, Arkansas. Thanks to everyone who followed the Humidoro on IG. He had like a little community of friends. He had his whole outside group of comrades who were into this cigar smoking thing. Anyway, so of course I checked followers and I plugged in Latoshia, and there it is. Easy peasy. But ma'am's page is private. Of course, she probably was under a directive to be private. But who else is spelling their name Latoshia who's following him? I wish the page were open, but it's not, of course. There's that. I feel like she's going to be in a corner, ducked off somewhere. He's had to have posted her somehow, some way. A lot of these people make mistakes. She's got to be ducked off somewhere. Let's see if he posted the night that his last. So it was April 4th. Ooh, baby, this is the post. This is his last post, guys. This is April 4th, 2019. This is the last drink. I drink a great deal. I sleep a little. And I smoke cigar after cigar. That is why I am 200% form. Winston Churchill. Interesting. And that was April 4th, 2019. That was his last day at the cigar club. Okay. Angel's Envy. I hope that drink was good because that was the last one he had. Baby. Okay. Okay. We just have to bring that little extra additional intel to the case. Okay. Let's see what's going on. Let's see his court. The honorable judge is still back in chambers handling that business. Did he start getting RIPs at this point? You're definitely going to be missed. Salute, bro, and you will be missed. I'm grateful that we crossed paths. RIP B. Perry, the smoking savant. His last post on his last day, he was over there at the Pocket. She mentioned the Pocket in her testimony. That's where they met up in Memphis, Tennessee. And the napkin says the Pocket. Okay. Drinking a little bit of Angel's Envy and enjoying a cigar. And the night before, he was there at the Pocket drinking Wild Turkey Rare Breed, a handmade cigar of a rebellion against frenzy and insanity. It means supporting contemplation over rash impulse and represents a civilized revolution. Sir, really? Okay. And only 24 hours later, was he a drunk? I don't know. Was he drunk that night? I don't know. I don't think so. He might, people have a drink and they're not drunk. So not to say that that's what you were saying, but we don't know. He belonged to a club. So the club, depending on because it's a private club, they probably could lay out bottles without buying a bottle. They might let you, they might put a bottle on the table. I don't know. It seemed like he was spending a lot of Miss Ma'am's money. So let me take a screenshot of this. His last post on Instagram. Okay. So that's pretty much, I guess we can still peruse, but people, like I said, people post stuff. I feel like Latasha would have been backed off in some corner. Look at the attractive bartender. You'd be so proud of me. I finally started smoking cigars. I just know you're in heaven smoking a cigar. Rest easy. Okay, Rachel. Rachel said, you'd be so proud of me. Rachel Joe Anderson. Jesus Christ is Lord. Okay, Miss Rachel. If you are in the bushes and you are from the group chat and would like to tell your story, if you were over there at the ethical slut group chat, won't you come? The doors of the email is open, okay? Email is open, all right? Just hit us up and tell your side of the story. We would love to hear from you, any of the sisters of the ethical slut chat. If you would like to give us a little more information about the friendship with Pastor, we would love to talk to you. So make sure to hit me up at ask@realtalkbougie.com or info@realtalkbougie.com. Okay. If you provided video evidence to the police, if you were part of the group chat, let us know. Will there be one to come forward? Do you have anything to share about your friend, sir? Okay. Oh, Cafe Havana. Wonder, was that in Cuba? Let's see. If we can find the Cuba trip, we might see Miss Ma'am ducked off somewhere. Miss Latasha. Casa Cuba. I'm sure he made sure Latasha was nowhere to be found. Get thee behind me. She couldn't be on the sis, you were not his girlfriend. You were not on the Instagram. He might have been on your private Instagram, but you definitely weren't on his. Okay. Team of teams. Okay. Okay, guys, I'm still listening out. Why does she look like Kaya? Okay. Oh, wait a second. What's this book? A Lesson Before Dying. Wow. This is a prolific, this is quite a interesting collection of reads by Ernest Gaines. Ernest J. Gaines, A Lesson Before Dying. What the irony of such, right? The wife went, so she went, oh, the wife went to Cuba. Latasha went to Israel, right? Okay, my bad. Wifey went to Cuba. Latasha went to Israel. Okay. A Lesson Before Dying. Okay. Good book. Okay. Let's keep looking. I wonder, is that the counter from the apartment? Latasha, are these some of the bottles you bought him on his kitchen counter over at the house with Miss Tabitha? How embarrassing. Okay, guys, court's back. Let's see.
Instruction the same, because I don't wanna, I mean, the length, I feel like it's duplicitous to put that in there twice, because the defendant testified she's treated as a witness, and the instructions say her credibility is determined by the same rules that the credibility of other witnesses is determined. And so the credibility of witnesses, there's a section titled that with everything that she's supposed to be given the same weight as everyone else. So I'm gonna deny that request at this time.
And Your Honor will not consider even adding the language that you had suggested about saying when she testifies, she's considered a witness.
I'm gonna leave it the same. All right, were there any other corrections? I gave you each a copy. Y'all gonna take a moment to look at that to make sure there's not anything else before we print them off.
If we can have it, please.
Okay, sure.
I mean, two things can be true at the same time. Clearly, a defendant can be a witness in their own trial. Like, I think that's obvious, but she's the the defense attorney is doing her job, number one, and that's just her job to do what she's doing. So we can't fault her at this moment for handling business. Okay. I wonder if the prosecution is going to go with their standard. We're going to keep this very short and cute. I really don't think they have to say a whole lot, just to be honest. The prosecution really did what they needed to do yesterday. They asked Miss Daniels very pointed questions to which she admitted. The evidence shows that ma'am has taken responsibility for the acts. There's no question that a homicide occurred, that there was a shooting of the wife, and she came to the location with
Intentionality,
firearms.
pattern instruction.
Which one? Which section?
What was added to the criminal attempt?
That's a pattern instruction for criminal attempt. First degree murder with serious bodily injury. That's the pattern instruction.
Is it the pattern instruction for regular first degree?
There is two separate instructions. It's one for first degree murder, and then there's a separate instruction for criminal attempt, first degree murder with serious bodily injury.
Yes.
There's a separate instruction.
I guess my issue is that we're adding language to the criminal attempt first degree murder that's not in the pattern instruction. This says the essential elements necessary to constitute first degree murder are, and then it goes into that paragraph that is not part of the pattern instruction.
I think that's what's, hold on. 401A.
I'm just going to say this. I think if they would have been able to open up those phones, baby, I think it would have been far more tragic if we really knew what Latosha and Brodes were up to. Furthermore, maybe even Tabitha, that phone would have been a treasure trove, because even just the assumptions off this Instagram are sending me. But, we can only just look at the pictures and blah, blah, blah. At the end of the day, some lives were saved by that phone not being opened.
That's telling the jury this is first degree murder, but it's different than the pattern given for first degree murder.
It's an attempt, so it said the defendant unlawfully killed the alleged victim, that the defendant acted intentionally. Oh, we forgot, and the killing was premeditated. One, I'm gonna make sure she had that.
I think the intent is when she said she grabbed a handful of bullets. Because truly, if your intent was to go to the park, maybe you need one or two. I'm not trying to be gruesome or grotesque, but you know what I'm saying? You wouldn't need a handful because one would render you incapacitated, you know. You know what I'm saying? Like, you don't need a handful for what? And then you end up in Memphis. I'm talking about even before she got there. Then furthermore, yes, you shot your whole clip and then you reloaded.
That's the instruction. That the essential elements necessary to constitute first degree murder are the defendant unlawfully killed the alleged victim. That's under the first degree murder. In count one, the defendant acted intentionally. That's there, and that the killing was premeditated.
Yes. But what I'm looking at on the instructions that you're giving for first degree murder says that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim.
Right. And so, what's the additional language is not there?
It just is.
She wants the judge to damn near prove Latoshia's mindset, but that's for the jury to make that decision. She doesn't want the language that the intent was there, but it's just jury instructions. At the end of the day, the jury will make the decision if the intent was there. You're not even wanting them to infer intent. You shot the lady. You killed her husband. What are you talking about? You went there with a gun and a handful of bullets.
I think it will be confusing to have two different definitions of first degree murder in the same.
The difference is that because it's criminal attempt first degree murder, there's a reference to Millen, State v. Millen, and the fact that you can have the intent to kill another person. And so I think that's why the additional language is there in criminal attempt first degree murder versus first degree murder, because of the fact that you can get criminal attempt murder by just having the intent to kill someone, not necessarily the person who is alleged in the indictment. So I think that's what the distinction is.
Okay. I just was concerned by the fact that we have two different definitions of first degree murder.
I think it's just different because of that. In the pattern instructions, that language is there, and I think it's because of their law, and that's bracketed language. What I included, so it's not always included, but I included that because there's an issue about intent. You know, whether she had the intent to kill Miss Perry. So it's bracketed language. It's not necessarily required to be included in there, but I included that because of the proof that came out.
Thank you.
All right. You're welcome.
We don't know. Maybe after, if they do press conference, they'll tell us, but we don't know. As far as being offered a plea, I'll look it up. I'll see if there's anything in the local papers. I'll take a look and see if I can find something.
Would Your Honor consider, given the issues about the voluntary manslaughter and second-degree murder, would you consider a sentence at the end of the first paragraph under second degree indicating with second degree, the jury should take it or should consider whether a heat of passion was present at the time of the alleged killing? Putting that they should be considering that at that point in time as a way to address that issue?
This will be a pattern instruction, so do you have any case law to say that I can't do that?
Your Honor you are allowed to change instructions. We're allowed to draft instructions and put them forward for the court's approval. They just have to comport with the law. And as long as they comport with the law, the court is allowed discretion within the jury instructions.
Okay, what did the jury ask for again?
So because of this issue, that is a very new issue brought up by that denial of writ, with Sotomayor basically telling Tennessee Supreme Court, you need to fix this. It is currently unconstitutional. We have been told by the United States Supreme Court that our jury instruction framework is unconstitutional. This is a way to address that so that Ms. Daniels gets a fair consideration by this court when they're comparing second-degree murder and voluntary manslaughter. And especially in this kind of case when we're saying this is a voluntary manslaughter, that for them to not be allowed to move to that section because of the way that our jury instructions are ordered completely denies her right to a fair trial. So if we just added a sentence to say, this is the distinction between voluntary manslaughter and second-degree murder, is that voluntary manslaughter requires the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Even if you just said, the jury should consider whether a heat of passion was present during this alleged shooting. Here.
I think it's already saying that though, because it's showing you a distinction between both, and so.
Yes, but it's not telling them to consider voluntary manslaughter yet.
What's the state's position?
The law in Tennessee is that you charge first-degree murder, second-degree murder, and voluntary manslaughter. Until that changes, I think that's what the court should do.
And I get your point, Ms. Speaks. I do, I understand what you're saying. It's just, this is the law, and I have to follow what the law is. But I get your point.
And I'm not asking you to change the law. I'm asking you to provide some clarification to the jurors regarding this. And that's what these instructions are supposed to do. They're supposed to help guide them through this process. And when we have a situation to where second-degree murder and voluntary manslaughter are sequential, they don't move to that heat of passion according to the jury instructions. They don't move to that heat of passion until they completely acquit of second-degree murder. Then if you don't tell them, you need to take this into consideration here before you, if in the decision on whether or not to acquit on second degree and move down to voluntary manslaughter, then they don't get to the point that they are able to consider that as an element. That's asking them to do the cafeteria style that we're not allowed to do.
So I feel like what she's saying, if I'm getting what she's putting out, is that if you guys watched Karen Reed, trial 1, when there was the whole kerfuffle about the jury instructions, and to also make sure to include the lesser included. So you're charged with this, but within this, there are 4 other options. So if you find that she is guilty of this, maybe instead of this, it's this, or it's this, or it's this, or it's this. It may be second degree, but it could be manslaughter. It could be involuntary. It could be accidental, blah, 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 whatever, right? So I guess what I'm understanding, because I'm not a lawyer, is that in Tennessee, there is not a very specific direction to that. So her fear is that they're either just going to go yes or no and continue, and that the instructions are vague and does not give a adequate roadmap. However, the judge's point is that is what the law is stating at this time. The defense attorney is saying that the judge has discretion to be able to make some changes, and maybe this judge doesn't want to deal with that and feels like that's a matter of law and that's not something that I'm able to change. And the jury instructions were probably good enough for the last murder case, and the jury instructions are going to be good enough for the next murder case, and I'm not willing to set precedent in this case. So maybe that's gonna, she didn't say that, but that's gonna be something you might have to take up on appeal in the future. But right now we're gonna deal with these jury instructions that have been used and that will continue to be used because our Supreme Court has not changed that yet. I'm thinking that that's what they're talking about.
I mean, these are the pattern instructions adopted by Supreme Court, and at this point, I'm gonna deny the request. I get it, but I'm gonna deny the request because that, I mean, these are what they have set out, you know, what we're to use. So at this point, I'm gonna deny the request.
Given the fact that
Lady, would you please sit your ass down? Like, we've entertained you for an hour.
the jury instruction requests specifically are supposed to be in writing, would the court give me a moment just to draft a pleading so that I can file it, to have it in writing to make the record?
Yes.
Thank you.
Okay, another delay. Another delay. Delay, delay, delay. Oh. She wants to draft a pleading for the record. Is it not on the record with the court reporter? Hasn't the court reporter made record? But she wants to file something formal so they have something to latch on for the appeal later, that they feel like the language was prejudicial or the language did not allow enough bandwidth, like enough room or opportunity for the jury to make an adequate decision based on, you know, Latoshia's specific murder deed. And this is stupid. Right. Technicalities. Hi, T. Collins. Hey, Boo. How are you? Good morning to everybody. Welcome, welcome, welcome. Guys, make sure that you have hit that Friday like for me. I was so appreciate it. Let me advance. We do have some time. Okay, let's advance. We have time. I forgot. Okay. We have a few little minutes. So look at us advancing. Okay, here we go.
I will include in that written request my additional request for the language regarding the defendant and witness credibility.
But other than that, there's no
Anything else?
objections. Was there anything else?
Oh, the issue, did you take out the language of the not pleading not guilty?
Yes, I took that out. Did the state have any correction?
Guys, I am checking for, was Latasha offered any plea deals at any point? I am reading an article really quick. Spokesperson from Walden University confirmed Daniels graduated with a Doctor of Social Work with a criminal justice concentration. We also confirmed Daniels graduated from University of Arkansas at Little Rock in 2003 after studying criminal justice and received a master in social work in
Before
2007.
the section on
Daniels
defendant.
is behind held without bond and is scheduled in court on that Thursday. Okay. Perry served as an executive pastor at Mississippi Boulevard Christian Church. Arkansas records show Daniels was a licensed certified social worker. Her license was issued in 2012, expires in 2020, et cetera, et cetera, et cetera. Okay.
Fine.
What's the state's position?
Let me back it up one more second because the lady asked for something else. It's like, look at the judge's face. Like, can you please sit down?
Before the section on defendant testifying.
What's the state's position?
I thought that's generally given when the defendant doesn't testify. So I'm not sure what the purpose of it is if the defendant testifies.
What's the question?
Your Honor, it's to clarify the burden of proof. It is to make clear, and I'm checking the burden of proof section now. But being clear that that does not place a burden of proof on the defendant.
The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains in the state throughout the trial of the case. The defendant is not required to prove her innocence. So I think that's, yeah. She doesn't have to prove anything.
She's trying to pull a rabbit out of her hat, and I get it. You know, she's doing her job, but it's like, ma'am, let's see. I don't see anything documented that, you know what I mean? Like, I don't see any news reporting that, you know, that Latasha Daniels was offered this, that, and the third, and it's going to trial. I'm perusing a few articles, so I don't see anything. Some states, some cities, they won't say. It's basically like, I don't want to say it's a secret, but it's sometimes confidential. And unless a plea deal is accepted, then, you know, there's nothing on paper that exists. It's a, you know, kind of a verbal, I guess, until if it's accepted, then it's drafted and accepted. But I don't know. I don't see anything mentioning anything regarding a deal. So they may have just said, you know, this is a solid case. We don't have to offer you anything. You didn't give us the code to your phone, so we don't need to offer, you know what I mean? She wasn't forthcoming and helpful in the investigation. i.e. her phone or maybe any additional information. Not that she has to provide that, but we don't know if she lawyered up immediately. We don't know if she offered any. So maybe they feel like you weren't helpful in the investigation of Boo, and we'll just let you fight it out. You know what I mean? You want to thug it out with us, we gonna thug it out with you. You know what I mean? So no deals. All right. I more and more, I don't know what the wife, and I'm gonna try to respect. She did a good job of keeping her privacy, but at the end of the day, I am gonna say, there's definitely more to this story. There's definitely more to this story. But they dodged a big bullet by those phones not being able to be opened. Perry was shot multiple times. They said something about him posting something on Facebook. Let me see if I can find his Facebook real quick. Perry told his wife that Daniel's comment made that seemed that her husband was having an affair. Perry's wife told police that Daniel's comment made it seem that her husband was having an affair with Daniels, but she was unaware. Daniels was taken back into custody and charged with first-degree murder. Daniels also at the hospital. Daniels was we read the affidavit, but Daniels was also taken to the hospital where she tried to escape. Police say they were trying to handcuff her and she shoved a police officer and took off running, then grabbed his uniform shirt and started swinging at him. Girl, that was so funny. If you didn't hear that, I have a video posted. It says it's the reading of the affidavit, the probable cause affidavit, and we talked about her assaulting a police. She's lucky she didn't get charged for that. Let me see where it says something about Facebook. All right, let me look him up on Facebook because I haven't done that yet. If his Facebook is still up. Oh my God, I was on mute. 2 years ago today, I began to measure my life pre and post your presence in it. It is immeasurable grief. It is if this immeasurable grief is the price I am required to pay for having had the opportunity to love and to be loved by you, it's pain well spent. Brodes Calvin Perry, my bro, the absence of you is harder this year than before. While the words has moved on to its latest chatter, those of us who loved you deeply still mourn the tragedy of your passing. I know you'd want me to carefully measure my words, so I'll say less. Yet I must say I'm still angry about your death. The justice has not been met out to your murderer, and the bitches who used your name for clout with the half truths and whole lies get to move on to the next clout chase, while those of us who knew you are still hurting. I love you more than words can say. I will always keep the light of your memory alive so long as I live, and will continue to vow to do whatever is necessary to bring justice to those you've left behind. Promises made, promises kept. I love you forever, Bro P. That's from Danielle Thomas. Baby, I don't know who Danielle Thomas is, but Miss Danielle, okay? Sunday afternoon at 4 p.m. service, my brother, Pastor Brodes, will be preaching. Not anymore. Baby, while everyone is glued to Brené's trial, I'm watching the Latoshia okay. Who is this lady? Is that the wife or is that Miss Latasha? Girl. Okay. Look at him and Miss Ma'am taking a picture. Ooh, ooh. Girl, we didn't know. Okay, let me. Why didn't I come to Facebook? Facebook had the pictures. Facebook always has the tea. Shouts out to Facebook. Good morning. April 6, 2019. I'm still paying attention to the feed, y'all. Hold on. They are not back yet. Okay. Facebook, where are you? Okay. The official statement from Mississippi Boulevard Christian Church, Disciples of Christ. It is with great sadness and heavy hearts that we share with you the sudden passing of our executive pastor, Brodes Perry. Please keep his wife and family lifted in prayer during this difficult time. Also, please keep the entire Mississippi Boulevard Christian Church members in prayer. We ask that you respect the privacy of the family and the church during this difficult and sensitive time. Pastor Perry was a phenomenal man dedicated to the kingdom of God, and service and heart will truly be missed by all in the bonds of Christian faith. Dr. J. Lawrence Turner. Okay, court has just come back. Hold on.
Pleads not guilty to the offenses as charged.
What's the state's position on
Either one of those is.
I'd prefer the second.
that? The defendant,
Pleads not guilty to the offenses as charged in the indictment.
defendant pleads not guilty to the as charged, is what if is charged? in the
To the
indictment?
offenses as charged in the indictment.
Okay.
And just semantically, I'd probably rather offenses charged rather than crime charged.
you mean on the heading offenses charged?
Yes.
What's the state's position?
Yeah, I give it an inch. I mean, it's a crime. It's charged as a crime, and that's what this charge says. So I don't know why we would change that.
Offense is charged crime, same thing. Offense is charged. So do you want to keep the language about the plea?
If we could just add that final sentence, the defendant pleaded not guilty to the offenses as charged in the indictment.
Okay, but the heading, you want?
Yes, then we can
offenses
leave
charged.
it offenses charged and plea. And then it outlines the offenses and then gives the plea.
Okay. All right, so were there any other changes besides that? Before we make the copies? I note your objection.
Thank you, Your Honor. I do have that written request on the way.
Okay.
I know Judge is tired of her, Miss Ma'am, because we are out here. Oh, I wonder. So maybe the jury's coming in now. Okay, guys, there's no sound, so just hold steady. They'll become. You see the judges coming back to her
When we
desk.
walked out was adding page numbers.
Oh. Page. What's your position, Mr. Nikki?
So she wants page numbers now.
Okay.
We don't, if you've already started.
I'm gonna. You know what? This judge is really nice, but I would have to give her just like a final counselor. This is going to be. This is a ruling. You've got one more suggestion, and this is the final edit. This is the final. So we've got one more. You try to run me back to my office one more time. You got one. This is your final edit. What else you got?
We haven't printed it yet. Okay.
Girl, if I were the JA, Your Honor, it's already done. I got it. I got you, Your Honor. It's on there. Here it is. It's on the printer. There you go. So I found St. Mark's Church, but is St. Mark's the one? They post so many pictures. If he is in here, it's so pushed down to the bottom because this was 6 years ago. Like they post a lot on their social media. They're very active. Let's see. Uh, look at Pat. Look at Brodes. Okay. All right. Well, hold on. I don't want to. Look at him down there looking goofy, looking goofy. I'm still trying to see where I see Latasha somewhere in the background looking odd and out of place. I wonder what she's going to come back with this time. I feel like the pastor very nicely gave her anything else. She's very patient woman. I think they're getting ready to come back again. Yeah, I keep going on mute because the dogs are, the dogs are dogging. They're doing what they do. So I am doing research for you guys. I did find a little bit of his homegoing service, but not a lot. It's some sign-in. What was that? This 6 years ago now? My Lord. Okay. That's it seems as though if people were having anything to do with this guy, they scrubbed it off of there. They cut tags and all the things. Nobody's really I don't blame them. I wonder where this took place though. Okay. Someone said it was a great service, and someone else said really was. I slipped in and slipped out. Ah! Oh God. Okay. He was a FAMU. I guess he was a FAMU graduate. Uh, uh, is this? Uh-uh. I haven't even taken a vote yet. I just don't think that there's any way for an acquittal. I don't see an acquittal. Are we even talking about that? Are we even going to waste our breath? I don't see an acquittal at all. Is it worth talking about? I don't see how anyone could, any type of way, find her anything. This is what my closing statements would be. Ladies and gentlemen of the jury, I don't know how anyone could find any way other than to a guilty verdict based on the evidence presented. Thank you, and we appreciate you listening. Ladies and gentlemen of the jury, ladies and gentlemen of the jury, girl, please, okay? No, ma'am. Okay. No, ma'am. No turkey, no ham, no biscuit. Okay. Uh, uh-uh. Okay, we're still waiting. I don't know who this other lady is in the pink dress, but that one lady was mad. That one post that I read, she said the justice hasn't been served yet, and those bitches who were clout chasing. Okay. I don't think this is Latasha. Hold on a second. Let's look at this while we're waiting. There's Latasha walking into the gun store just as on an errand as anything else. Okay. She just walked in like, okay, where's the 9 millimeters? Okay. All right, I'll take that. I'll take that. And I'll take, do you take American Express? Okay, that looks good. All right, I'll take it. Thank you very much. With her little business casual Friday outfit on, light color khakis, little jacket, her transition lenses. Okay, thank you so much. Have a great day. Yeah, I'm on my way to Memphis for the weekend. Okay, and yes, she has on her heels. Okay, thank you. Okay. Hi, can you tell me where the 9 millimeters are? My boyfriend took my gun. I need another one. Yes. Okay. Keonce, we're not going to do that today, hon. We're not doing that today. Where do you see the lady in the pink dress? Hold on a second. Lady in the pink dress. Let's hold on. I thought that was Brodes. No, it's not him, but I'm okay, it's not it. Okay. Hold on. She was in my other search. Hold on a minute. Right here. I don't know whose video this is, so I don't want to play too much.
Is glued to this Brene, Akira, and Tim debacle. We have to talk about this horrific, fatal 2 weeks later. And
I don't know who this lady is. I've seen him with her in a couple of photos. I don't know if that's his wife or not, so I don't want to put too much. I found a picture of Latasha with him. Hold on. I don't know if you guys saw it or not. Image file. Hold on, let me upload it really quick. I'm like, it's taking a really long time to add some page numbers, y'all. My Lord. Ooh, ooh. There she goes. There's wife. She says she is trying to literally drag it out. Look at the judge. The judge is like, you getting ready to work my last nerve. Okay, hold on.
15 lunch close. Just kind of as a logistics matter, are we planning to charge lunch close? It's 11:15 now.
I know.
Can you let me manage my courtroom? You worry about your client. I'll manage the court. See, I know this lady probably, she's the smiling judge. She's very sweet. She has a lovely disposition. That lady needs to relax.
It's looking like it's gonna be that way, but I was hoping that we could get it done before lunch. That's probably not going to happen, but I was hoping.
Thanks to you. Thanks to you.
You could limit the time.
We could do that. But, okay. All right.
I feel like, I don't know in North Carolina if we had a waiting period or not. I feel like we had to clear some paperwork and they called us, told us everything was good. I don't know. I think we had to go downtown to the sheriff's department and get a license. Then you take your paperwork to the gun store. I forgot. It's been so long. Went downtown, filled out some paperwork, and they asked you how many do you need? And you can get up to however many. And then you take that paperwork to the gun store, which I guess means you've been to the sheriff. They've registered you. They've cleared you able to buy. And then you make your purchase. I feel like that's what it was, but I just don't remember. It's been so long. I do remember having to go to the actual sheriff's department downtown and fill out paperwork and pay for licenses. I feel like it could have been 3 days. It could have been a week because it was one of those things where you fill out the paperwork and had to come back and pick up the paperwork. So that may have been the waiting period because then when we got the paperwork, you could go to the store and make your purchase. I don't remember. It's been a very long time. Ooh. Okay, Friday Child, period. Cash and carry. Is anyone having anything for lunch yet? Y'all, it's Friday. This was a fun week. I don't know what we're gonna do. I'm gonna look up the Brene thing. I don't even know if it's being televised. I think people are saying it's playing out on TikTok, maybe. Brene, the alienation of affection. Okay, this is what I know about what happened with Brene. It's like an alienation of affection lawsuit going on upstate here in North Carolina. I think the husband got arrested yesterday because he carried a weapon to the court grounds or something, into the courthouse. He carried a gun. He got arrested. One of the I don't know if it's the plaintiff or I don't know who's suing who. I'm going to be honest. Oh, the wife is suing the girlfriend. The wife has a lawyer. The girlfriend does not. The girlfriend was questioning the wife on the stand. They kept getting into it. Like, it sounds like a complete mess. Oh, there is some film. What? Uh-huh. Stop it. Okay, y'all, I'm gonna collect as much as I can about this case. We are watching a serious murder case right now, but there is some foolishness going on in North Carolina with some content creator mess, and we'll talk about that. We're not going to even inject all of that into this because this is serious. Someone lost their life, even though he had a lot going on too. We're not gonna do that because I'm on TikTok and what I'm seeing right now, I can't do it. I can't do it. I don't want to cut up too much. We're not doing that today. We are not doing that on today. Okay. All right. Let me get up off of this TikTok. TikTok is a mess. Yes, that's true. It's what I just saw on TikTok. We just need to have our own little hour. We just need to have a separate hour, and we're not going to put that in this because it looks like a bunch of clownery. It looks like a bunch of clownery, and we are about, this is a very serious, dignified murder trial of some ethical sluttery and some, what was it called? Consensual non-monogamy. Baby, no. That foolishness going on up in Raleigh right now, girl, it looks like a whole clown show. But we're going to talk about it though. We're just not going to talk about it right now. Okay, salad, very nice. I'm eating 2 eggs on a piece of toast. It's pretty good. It's very good. Wine for lunch. Okay, wine. what was it called? Ethical non-monogamy. You know what? By the time the jury comes in, it's going to be time for them to go to lunch. I'm sorry. I think starting court at 11:30 justifies. Do you guys mind if we work through lunch? Kathy, you didn't miss a thing other than me going through the Facebook page. Um, if you want some TT, go slide back. But I went through the Facebook page. I went through the Instagram page. We relooked at the video going into the gun store. We ran back a few things. We've been keeping it cute, but no, you have not missed a thing other than Miss Ma'am's lawyer irking the ever living fuck out of everybody, okay? And trying to make our wonderful, very pleasant tempered judge act out. This lady has some patience on top of patience. Oh, charcuterie with fresh yellow, red, and orange bell peppers, blueberries, blackberries, slice of cranberry walnut loaf, boiled eggs cut in quarters, and Oikos strawberry yogurt. That sounds like a beautiful lunch. Okay, listening and giggling. Okay, lovely. It's giving, I need to play some samba music for that. It's giving very elegant and classy. Okay, giggling coming with a very bougie lunch. Okay. Okay. Oh my God. Okay, can we get back? Court, where are you? Judge? Hello? I had a whole lunch meeting where I asked and learned questions. Okay. Where I asked learned questions, excuse me. And these fools still haven't closed. You know, it's getting bad when I start using the sound effects. I'm losing it. I'm trying to maintain, a professional decorum, for this particular trial, but I'm losing it. I'm starting to get Friday silly. And once I go there, it's going to be hard to reel me back in. Um, it's getting a little, I'm getting a little punchy. I feel like this is going to stretch. Somebody in the jury probably can't stay past a certain time. You like the sound effects? Me too. Sound effects are always wonderful. They're fun. Okay, let me go back on Facebook and see if I can find anything else. I did find a snippet of Brodes Perry's homegoing. I don't have, let me see. Oh, thank you, Lee. Thank you for supporting. I appreciate that very much. Yes, thank you for supporting the channel. I appreciate that. And happy Friday to you. Thank you very much. This is definitely not how I thought court would go today. You know what I'm saying? I don't know. I let all my expectations go. I let all of my expectations go. I just knew something was going to happen. Okay. All right, let me see if I can find some more. Let me see if I can find more Brodes Perry posts. All right, I'm putting you guys back on mute for a minute. The dogs are dogging. Okay. Am I still here? Hold on. Okay. Did I lose connection with Facebook? I feel like I lost connection with Facebook. Facebook connection has been weird lately. Anyway, let me see if I can get it back. Okay. This the lady in the pink dress, I'm not sure if that's the wife. That might be the wife in a pretty pink dress. This is obviously not. That's the mistress. This was that funny post. Go back if you want to see what it says. There's him and ma'am. As Memphis police are investigating the shooting of Pastor Brodes Perry by his side chick, Dr. Latoshia Daniels, sources say the reason that there are no official charges is because the killing is being investigated as if the wife pulled the gun first and that Daniels shot in self-defense and if the wife shot her husband. Oh, they were investigating everything. Okay. Okay. You know, she was happy she had this one public picture, and this is the one. This lady says right here, she is my family as well. And without even knowing this, I already knew it was not her because he called to come get her and it wasn't premeditated. And she's a good person. And the wife let her in with intentions to kill her. In reality, what wife just going to let another woman pick her husband in her face with some envy? I honestly feel like he shouldn't have personally told to come get him from his home. He shared with his wife, and as a man of God, he knew better and he paid for his mistakes, but both women lost their souls over adultery. I'm not trying to step on anyone's toes, but this is my family, and I got up and my family and just got up in the devil's intentions. And in the end, God is by her side, and as she's going through this, her son, and she is going through this. Her son committed blank. So consider her feelings and mind state. By God will never forsake anyone. Just pray for her and justice will prevail. Y'all, we didn't know that. So what, one of her sons or her son, I don't know if this is true or not. I really don't. But someone said that let me take a screenshot. So you guys can read it for yourself. I'll take a screenshot and you guys can. She mentioned something about it in her book. Wow. Which you sent me last night. I didn't have a chance to read that. Interesting. I'll share it. I'll put the link. Is that a link we're allowed to share? I'm assuming we can share that, right, Bible lady? I don't want to okay. Thank you. We're still waiting for court to come back. I'm keeping my ears open. I know the judge might be like, you know what? Y'all get your mind right. We're coming back. Y'all, I want you guys to take a snack break. Get your minds right. And when we come back, we're going to end this with little to no interruptions, period. The time is filled with swift transition. Brodes, I love you beyond words can ever articulate. You were more than a friend. You were my big brother. Death cannot separate me from the love we shared. Fret not, me and your other little sis, Chriselle, will hold you down forever. Promises made, promises kept for you, for Tabitha, for your legacy. I will love you always, Brodes Perry. This lady Danielle is going through it. I'm so sorry for your loss. I literally can't take this. Praying for the UCC family. I'm really sorry for your loss, Danielle. Is she saying anything about it now? I don't see her talking about the trial now. Okay. All right, let me see what else I can. Did you guys see his last post? This is his last post before he went out and met Miss Ma'am on the streets, Miss Latasha. He was over there at the Pocket Club. This is his last post on Instagram, Memphis, Tennessee, April 4th, 2019. He was having some Angel's Envy bourbon with a cigar. And this was his last post on his Cigar Savant Instagram page. And this was his last post, Angel's Envy. If you hadn't seen that, just go back to the beginning. We've been small talking for 2 hours. Can we hear his voice? Is there nothing recorded of him speaking? Let me see if I can find something. There's got to be something, right? It's crazy to me. I almost feel like the church would have something, but the church has such an active social media. Like they have so many posts. I just keep scrolling back. All right, let me see if I can find. I'm going to do some. Let me just get on Google. Oh, here's the judge. We are always so on time with our small talk. What's wrong? I'm here. No, I'm live. Okay, what's going on, guys? Bougie is stay-at-home mom. Sometimes she'll let the dogs out, go do something. What's wrong? You can't hear. Oh, that's odd. I can hear. Okay, hold on. So you can see, but you can't hear. Okay. I wasn't reading the chat. I was researching. The trial feed has no sound. Okay. All right, let me just. Okay. It's showing that it's sharing. Okay. All right, let me just reshare. But you guys could hear up until just now. Hopefully it's going to.
Intentionally.
You guys hear? You haven't heard anything. We can't hear the video. I got you. Okay. When did you start to not? Okay, let me pull up my phone so I can kind of figure out when you started to not be able to hear. Now you can hear. Okay. All right. So you want to go back to the jury instructions? Okay.
Such as telephone, cell phone.
All right, let's go back to the beginning of the jury instructions. My bad, y'all. I didn't know. I was actually sitting right here, but I was not reading the chat. I was researching one of the many things you guys asked me for. So, okay, I'm going to put you guys back on mute and I'll pay attention to the chat. But yeah, okay, here we go.
The defendant, Latoshia Daniels, consider all of the evidence in light of your own, in light of, and in harmony with the versus Latoshia Daniels you on the. You may be seated. Good morning. Good morning. While we're ready to get back to work, it's now time for me to instruct you on the law. If you could pass them a copy of the instructions. State of Tennessee versus Latoshia Daniels, indictment number 2501253. Members of the jury, the evidence in this case has been completed and the arguments are soon to follow. Now it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions. It is your duty to carefully consider all of them, The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experience in life. Offenses charged and plea. The defendant, Latoshia Daniels, is charged in count 1 of the indictment with the crime of murder first degree. The offense necessarily includes the lesser offenses of murder second degree, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The defendant, Latoshia Daniels, is charged in count 2 of the indictment with the crime of criminal attempt murder first degree. The offense necessarily includes the lesser offenses of criminal attempt murder second degree, criminal attempt voluntary manslaughter, and reckless endangerment. The defendant, Latoshia Daniels, is charged in count 3 of the indictment with the crime of employing a firearm during a felony. The offense necessarily includes the lesser offense of possessing a firearm during a felony. The defendant pleads not guilty to the offenses as charged in the indictment. The law makes it the duty of the court to give in charge to the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them on the trial and under the law given them by the court, render their verdict with absolute impartiality. No independent research or discussion. You as jurors must decide this case based solely on the evidence presented here within the 4 walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I hope that for all of you this case is interesting and noteworthy. I know that many of you use cell phones, the internet, and other tools of technology. You also must not talk to anyone about this case or use these tools to communicate electronically with anyone about the case. This includes your family and friends. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. Notes. Members of the jury, you have been allowed to take notes in this case. The court charges you that these notes are for your individual use only, and you should not use said notes directly or indirectly to persuade other jurors as to the accuracy of said notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by the maker of said notes as an aid to his or her individual memory. Indictment. The indictment in this case is the formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements and arguments of counsel. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. The court will now explain to you the law applicable to count 1 of this indictment, murder first degree. First degree premeditated killing. Any person who commits the offense of first degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodes Perry, and 2. That the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim, and 3. That the killing was premeditated. Intentionally means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the crime after the passion has subsided. Second-degree murder, knowing killing of another. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodes Perry, and 2. That the defendant acted knowingly. Knowingly means that a person acts with an awareness that her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intends to cause result the death of a person, then the killing of another, even if not the intended victim, would be second-degree murder. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodes Perry, and 2. That the defendant acted intentionally or knowingly, and 3. That the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. Intentionally and knowingly have previously been defined in these instructions. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant killed the alleged victim, Brodes Perry, and 2. That the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and a degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally and knowingly have previously been defined in these instructions. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant's conduct resulted in the death of the alleged victim, Brodes Perry, and 2. That the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, and recklessly have previously been defined in these instructions. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's action need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. The court will now explain to you the law applicable to count 2, criminal attempt first-degree murder charged in this indictment. Criminal attempt first-degree murder. Any person who attempts to commit first-degree murder where the victim suffers serious bodily injury is guilty of a crime. For you to find a person guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant intended to commit the offense of first-degree murder against alleged victim Tabitha Perry, and 2B, that the defendant did some act intended to cause an essential element of first-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part, and 3, that the alleged victim Tabitha Perry suffered serious bodily injury. New and known means that a person acts knowingly with respect to the conduct or to circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Intended, intending, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The essential elements necessary to constitute first-degree murder are 1. That the defendant unlawfully killed the alleged victim, and 2. That the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that she did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a bodily function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Criminal attempt, second-degree murder. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, and 2B, that the defendant did some act intended to cause an essential element of second-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended, intending, intent has previously been defined in these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The essential elements necessary to constitute second-degree murder have previously been defined in these instructions. Criminal attempt, voluntary manslaughter. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of voluntary manslaughter, and 2B, that the defendant did some act intended to cause an essential element of voluntary manslaughter to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intended, intending, intent have previously been defined in these instructions. The essential elements necessary to constitute voluntary manslaughter have previously been defined in these instructions. Reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in a zone of danger. The zone of danger is that area in which reasonable probability exists that the defendant's conduct will place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Recklessly, intentionally, and knowingly have previously been defined in these instructions. The court will now explain to you the law applicable to count 3, employing a firearm during a felony charged in this indictment. Employing a firearm during the commission of a dangerous offense. Any person who employs a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant employed a firearm, and 2, that the employment was during the commission of or attempt to commit criminal attempt first-degree murder against alleged victim Tabitha Perry, and that the defendant acted intentionally, knowingly, or recklessly. Employ means make use of. Firearm means any weapon designed, made, or adapted to expel a projectile by the action of an explosive or any device readily convertible to their use. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and justifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that a defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim, Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Unlawful possession of a firearm with intent to go armed during the commission of or attempt to commit a dangerous offense. Any person who possesses a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant possessed a firearm, and 2, that the possession was with the intent to go armed during the commission of or attempt to commit criminal attempt first-degree murder, and 3, that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, recklessly, intent, and firearm have previously been defined in these instructions. Possession may be actual or constructive. A person who knowingly had direct physical control over an object at a given time is then in actual possession of it. A person who, although not in actual possession, knowingly had both the power and intention at any given time to exercise dominion and control over an object is then in constructive possession of it. Possession may also be sole or joint. If a person has actual or constructive possession of the thing, possession is sole. If 2 or more persons have actual or constructive possession of the thing, then possession is joint. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that the defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim, Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Presumption of innocence. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and that this presumption stands as a witness for her until it is rebutted and overturned by competent and credible proof. It is therefore incumbent upon the state, before you can convict a defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and state of Tennessee before the finding of this indictment, and that the defendant at the bar committed the crime in such manner that would make her guilty under the law heretofore defined and explained to you. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof general. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. and this certainty is required as to every element of proof necessary to constitute the offense. Burden of proof, elements and date of offense. The state must have proven beyond a reasonable doubt all the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Impeachment of witness. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with the witness's evidence on the stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Excuse me. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it plainly appears that some witness has testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony about the facts and circumstances proved on the trial. Credibility of witnesses. You should consider all the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are, based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything that witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors. 1. How the witness looked, acted, and whether the witness appeared to be telling the truth when he or she testified. 2. Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard. 3. Whether the witness's statements were consistent and how believable the statements were. 4. Whether the witness had a motive to testify truthfully or to testify untruthfully. And 5. Any proof presented of the witness's reputation for telling the truth. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it plainly appears that the witness has willfully testified falsely. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown and all the evidence in the case tending to corroborate or contradict him or her. Expert witness. During the trial, you heard the expert testimony of Erica Curry, a forensic pathologist. Dr. Amanda R. Bidding, during the trial, you heard the expert testimony of Erica Curry, in forensic pathology, Dr. Amanda R. Bidding, PhD, in forensic and clinical psychology, and Special Agent Brock Sane in firearms identification. All were who were described to us as experts in their fields. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion Does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Identification. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which she is charged. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Latoshia Daniels, committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she has been identified as the person who committed the crime charged, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether she has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. Evidence, direct and circumstantial. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard what happened firsthand. If witnesses testify about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both circumstantial, both direct and circumstantial, and give it whatever way you believe it deserves. Defendant testifying. The defendant having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will give to the defendant's testimony in this case such weight as you may think it is entitled. Unanimous verdict. The verdict must present the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliver with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Unanimous means agreeing in opinion, being in complete accord, agreement of all jurors in holding one and the same opinion. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or you have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You should not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that account, you should return a verdict of not guilty and proceed to the next count. The charged offense in count 1 of this indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of first-degree murder as charged in count 1 in indictment 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of lesser included offense in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of lesser included offense beyond a reasonable doubt, if you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 1 in indictment number 2501253. Insert instead blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 1 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count 2 of this indictment is criminal attempt first-degree murder. The lesser included offenses in order of consideration from greatest to least are criminal attempt second-degree murder, criminal attempt voluntary manslaughter, reckless endangerment. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of criminal attempt first-degree murder as charged in count 2 in indictment number 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt to this offense, you will next consider her guilt of lesser included offense in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 2 in indictment number 2501253. Insert instead blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count 3 of this indictment is employing a firearm during a felony. The lesser included offense is possession of a firearm during a felony. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of employment of a firearm during a felony as charged in count 3 in indictment number 2501253. If you find the defendant guilty of this charge, you must identify the felony, either criminal attempt first-degree murder checkbox, criminal attempt second-degree murder, criminal attempt voluntary manslaughter checkbox. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of the lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 3 in indictment number 2501253. Insert and said blank the lesser included offense If you find the defendant guilty of the lesser included offense, you must identify the felony, either criminal attempt first degree murder, criminal attempt second degree murder, or criminal attempt voluntary manslaughter. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 3, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. Selecting foreperson. When you retire to the jury room, you will first select one of your members as foreperson, who will preside over your deliberations. When you have reached a verdict, you return with it to this courtroom, and your foreperson will announce the appropriate verdict form to the court. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdict as truth dictates and justice demand. Signed, Judge Jennifer Fitzgerald, Criminal Court, Division 2. All right, so I have given you the law in this case. We're going to recess for lunch, and when we come back, you'll hear the attorney's closing arguments. And I have to remind you again, we're still not ready to discuss the case, okay? So I'm gonna excuse you for lunch. We'll come back, I guess at 1:45. I'm not sure if lunch too yet. We'll come back at 1:45. But I'm gonna excuse you for lunch, and we're still not ready to discuss the case.
Let's put your paperwork in your chairs, please.
Latoshia's attorney is annoying. Did she say may I approach? Okay. Yeah, she's really annoying. Ooh, baby. I almost feel like shutting this one down. You want me to keep it open for lunch? Because, baby,
Copy stamped or did you?
All right, we can come back at 1:45.
can we make it 1:45 sharp? Can we be sharp today? Can we just make this one last one sharp? Yeah, she ruined her life. She was ridiculous. She was redamned donkulous. They could have deliberated over lunch. Yeah, but Miss Thang, Miss defense attorney doing her job, which I get it. She was doing her job to the fullest. Created delay after delay after delay, stall tactic after stall tactic. Okay. They made me, I'm exhausted. Okay, guys, let's take a break. You know what? I could just make a new one. Should I shut this one down for 3:00? And then you guys will still have a chat room. Defense doesn't. Because then we'll have the verdict one. Okay, you guys stay put for just a second. I'm going to put up another room. And then, yeah, because we did a lot of talking and blase and all the things. So, yeah, give me just as you guys hold tight. Please make a new one because I'll forget to come back. No, you won't, T. Collins. Don't say that. Don't say that. Okay, hold on a second. You guys sit tight for 2 minutes. Okay, I'm setting it now. Okay, I think it's there. Okay, you guys. You guys have a nice I'm going to roll this over so you guys will roll in there. Just hit the notify me now or notify me button. That way you'll be notified as soon as I hit the go live, but I set it up for 2:45. So beat me there, don't meet me there. I'll see you guys 2:45 sharp. I'm sure they won't be getting started till 3:15, but we know how to we'll do our thing, okay? All right, you guys, go have lunch, go take a break, get up from your computer, do something, get some air, and I'll see you guys in a little bit, okay? All right.